circumstantial evidence that the state intends to present that goes squarely to this issue is Mr. Baldwin knew he had a real gun in his hand. Mr. Baldwin specifically asked for the biggest gun that was available. Mr. Baldwin knew and understood that dummy rounds look identical to live ammunition. That's the foundation. So before Mr. Baldwin has ever even encountered training by Ms. Gutierrez, that's where we are. He then arrives to his training with Ms. Gutierrez and doesn't pay attention. Not only did Ms. Gutierrez indicate that he didn't pay attention, Ms. Zachary actually took a video of him not paying attention. And it's one of the exhibits that will be used in the destruction of evidence motion later today. So he decided not to pay attention during his training. Then, and look, anybody who looks at Ms. Gutierrez understands that Ms. Gutierrez hasn't been alive long enough to legally own firearms. So there has to be some question about, is this person really qualified to have this job? Any reasonable human being would have that concern, and many of the crew members actually mentioned that to the producers. How can this lady be our armorer? She's like in her early 20s. So Mr. Baldwin certainly understood that. He had a bad armorer. She wasn't doing proper safety checks. His experience in the film industry is absolutely circumstantial evidence that he knew that when she was doing these safety checks that she wasn't following the rules. Absolutely, the court is right. He also understood that Mr. Halls was not checking the gun with Ms. Gutierrez every single time. We know that he knew that because that's what he said to law enforcement on October 21st. So we get to this point. Now let's take into consideration that there are two other actors on set that Mr. Baldwin can see dry firing their guns into the ground 10 times after the gun is handed to them by Ms. Gutierrez to ensure that every single round is inert. Are those actors on my witness list? No. Do I have plenty of other witnesses who are going to come in and say, we saw those people dry fire their guns into the ground every time she handed it to them? Absolutely. Plenty of witnesses are going to testify to that, and Ms. Gutierrez herself should be able to testify to that based upon the court's ruling, because that certainly wouldn't be anything that she could assert her fifth to. So that's where we find ourselves at this point in time. Now, what Mr. Bash is telling the court, which is absolutely false, what he's telling the court is, unless this gun has a live round in it, it is completely harmless. And he didn't realize that there was a live round in it. Patently false. Mr. Baldwin himself, as I recall, had a conversation with law enforcement, and I may be wrong. I've read a lot of transcripts. He indicated an awareness that if he is handed a gun that has a blank round in it, but also has a barrel obstruction, that is fatal. That can kill someone and has historically killed people. I believe that is the circumstance of the death of Brandon Lee that almost everybody who works in the film industry is familiar with. So Mr. Baldwin didn't necessarily have to know there's live ammunition in this gun. He had to understand that the gun is real. Real guns are dangerous. Dummies look exactly like live ammo. Even if there's not a live round on set and she put a blank in instead of a dummy and the gun had a barrel obstruction, Helena Hutchins is dead. She's dead. And she's dead because he didn't participate in the safety check. And listen, we agree, and we have always agreed that under the SAG guidelines, which do not dictate New Mexico law, the SAG guidelines indicate that that is optional. He chose not to participate, and I'm sure that's a decision that he's grown to regret. So he chose not to participate in that safety check. Then he decided to point a gun at a human being, cock it when he wasn't told to cock it. We have plenty of video of him cocking guns when he wasn't supposed to, when he hadn't been told to, when the scene didn't call for it. And then, of course, he pulled the trigger, killed a woman, and seriously injured someone else. So that's the landscape, and the court is absolutely 100% correct. The defendant has spent pages and pages and pages and pages arguing, we don't agree. We don't agree to the facts. There are really no stipulated facts. The state isn't stipulating that in order for that gun to have killed someone, it had to have live ammunition in it. Everybody knows that's not true. Now, let me clear up a couple of other issues. The reason that these safety rules exist, the entire reason that the SAG Safety Bulletin number 1 exists, is because of the risk that live ammunition could find its way on set. If there was absolutely no chance that live ammunition could ever find its way onto a movie set, why have these rules at all? You've got two actors standing right next to Mr. Baldwin who certainly understand that there's a significant risk of live ammunition, or they wouldn't be firing their guns into the ground right in front of him. Now, our expert, Brian Carpenter, will testify, and testified before the grand jury, and I think he even testified during the Gutierrez trial, that as an armorer, he himself has found live ammunition on a movie set. So what Mr. Bash alleges with regard to the distinction between involuntary manslaughter and second-degree murder really, I don't think, gets him where he needs to be. If I am an actor and I have reason to believe that I understand that there is a substantial risk that there is live ammunition on a movie set, and I take that gun and I point it at a person and I cock it and I pull the trigger, that is second-degree murder all day long. We can argue about that all morning, but that's not going to change. You know, I think that where the parties disagree here is when Mr. Bash was talking about the link, the link between the subjective knowledge and the offense, the link between the conduct, the subjective knowledge and the offense. We disagree on what the link is. Not only do we disagree on the vast majority of the facts, we disagree on that link. This motion by Mr. Baldwin absolutely cannot be granted by this court. There is a plethora of case law that says you can't do it. And what is happening here, which is what frequently happens in this case, is the defense attorneys are coming forward to the court and they're saying they're making statements that are not at all based on the evidence or the future witness testimony. One of those statements that was given today, of course, is Mr. Bash's statement, this gun can only kill someone if it's got live ammunition in it. Absolutely false. And Mr. Baldwin knew that was false. So we need to simply rely on New Mexico law. We have an extraordinary amount of circumstantial evidence that goes directly to this point. Some of that evidence you may see this afternoon because it's relevant to another motion. The court, if the court in Cerna, which is the unpublished case that the defense, that the state cited, that the defense was certainly aware of. They were aware of Cerna. They were aware of Gomez. They didn't cite him because they were hoping, I guess, we wouldn't find him. So when you look at Cerna, there's a video. There is a video of a person driving and a pedestrian stepping out in front of them. And the only dispute between the parties is exactly what Mr. Bash is bringing to the court's attention today, which is, with substantial risk, how can you get there when you look at this video and all this lady, she wasn't speeding. All she did was just kind of make this turn and hits this pedestrian. And for heaven's sakes, it was an accident. And in that circumstance, the court said, no, there are disputed facts. There are disputed facts here, and we are asking the court to follow well-established New Mexico law and deny the defendant's motion. Thank you.
Response, Mr. Bash.
Thank you, Your Honor. Much of what the government just said is incorrect, but as an umbrella point, much of what the government just said is waived. It appears nowhere in their opposition brief the point about blanks, the point about what two other actors were doing on the set. There's been a lot of sandbagging in this case. It's not proper for when we make an important dispositive motion, the state not to present those arguments in their written submission and then to debut them for the first time at argument. The arguments are wrong, and I'm happy to address them, and I will in a second. But a lot of the points you just heard are not found in the brief of the state, and that you can't raise something at an oral motion for the first time without previewing it. So let me take each of those points in turn. Ms. Morrissey went over a lot of their allegations, and some of them just have obviously no bearing on the issue before the court. Whether he selected the biggest gun, whether Ms. Gutierrez looked too young for the job, that has no bearing on whether he had a subjective knowledge of a substantial risk that the gun in his hand could kill somebody. They've given a lot of facts. Let's give them all those facts. Let's give them all the jump balls. Let's say that they're right about everything they say. That does not establish the element of the offense. And we've been over some of those in the opening presentation, that he had the gun in his hand, that he knew dummies look like live rounds. The fact remains that they told a jury to secure a conviction that everyone on that set did not believe there were live rounds in that gun, and that it was inconceivable there could be live ammunition on that set. And everyone includes Mr. Baldwin. Now, they've raised two arguments. I guess they've realized that they have a big problem, because if they can't show that he had a subjective awareness that that firearm was dangerous in his hand, they can't prove their case. And so they've raised two totally new arguments, which were not in the opposition brief. Someone can correct me if I'm wrong. I'm doing it from memory, but I don't remember seeing these arguments in the opposition brief. First, they say that Mr. Baldwin saw two actors dry firing their guns, but they're not going to call those actors, but they saw it. I don't see that anywhere in the brief. Second, they say that it's not true that you need a live round. In certain circumstances, a blank could kill someone because there could be an obstruction in the barrel and it could go off. But no one contends, Your Honor, that he thought there was a substantial risk that that gun contained blanks, because as everybody knows, and I'm sure the court is very familiar after sitting through the Gutierrez trial, they look completely different than dummy rounds. Dummy rounds are the ones that look like live rounds. Blanks look totally different. And I'm not aware the state has ever contended that Mr. Baldwin was aware of a substantial risk that Mr. Halls or Ms. Gutierrez loaded blanks into that gun, which looked totally different. It's not even remotely realistic that that was a risk after two professionals loaded the gun, that they accidentally loaded it with blanks. So that is an argument that the state just made up at argument. They didn't even include it in their written briefs, and it's completely preposterous in light of the reality of what blanks look like. It's an argument to try to get past a dispositive motion that doesn't actually have any weight. I would just add that I think they would have a huge problem with the foreseeability element if their theory was that he foresaw that there could have been obstruction that could have injured somebody, but actually what happened was totally different, and so he's guilty. I don't think they could satisfy foreseeability, but at any rate, the argument's waived, and it's factually ludicrous given that these things look different. There's no way he could have had a subjective awareness that there was a risk they were putting blanks into that gun. Ms. Morrissey referred to the SAG guidelines, and they say we have these prophylactic rules under the SAG guidelines because, you know, there's some chance of live ammunition, and so you can never say there's no chance. Again, let's assume she's right about all that. I don't want to get into whether she's right about the purpose of the SAG guidelines. The standard is not no chance. The standard is a substantial risk. You heard it again. They can't argue substantial risk. They can't argue subjective awareness of a substantial risk. They would have charged second-degree murder if they thought they could argue it. So they moved the goalpost. And they've moved the goalpost to, well, we can't say there's no chance. I mean, there's always some 0.0001% chance of anything happening. But that's way far away from the element of this offense, which is substantial risk. She doesn't argue that properly because she can't argue that. She changed the goalpost. I heard her say something about the second-degree murder. Well, you're just wrong about that. Mountains of case law say you're wrong. There was no case law cited. There was no logical reason given. Second-degree murder in this state requires a substantial probability. If the state could allege that Mr. Baldwin thought there was a substantial probability that there was live ammunition in the gun and could satisfy all the other elements, that would be a different story. But what we're saying is they haven't even alleged a substantial risk. There's a big delta between strong possibility and substantial risk. And if they can't even allege that, then it's not involuntary manslaughter. It's an accident for which he's not criminally liable. I heard Ms. Morrissey say that there's a plethora of case law that says you can't do a full and font motion in these circumstances. There's not. They don't cite it. They just keep saying there's a plethora of case law. Moreta stands for the exact opposite proposition. It says generally they're not going to be successful. We have no truck with that. Of course, generally, the prosecutors are going to be able to get intent to the jury. But this is an extraordinary case where they're charging somebody with an accident based on a movie prop when they told another jury that everyone thought it didn't have live bullets in it. This is an unusual case. And Moreta would have had one sentence of analysis if the rule was you can't succeed on a full and font motion on a question of intent. It didn't. It went very carefully through the allegations, and there was an attached affidavit, and it went very carefully through all that and said, okay, the state has enough here to prove the case. So they're wrong about that. And finally, I mean, Ms. Morrissey says, well, I know why the defense didn't cite Serna because they're scared of it. I mean, it's an unpublished non-precedential decision that alternatively applies a test that the Court of Appeals rejected in 2 published decisions. Okay, so it's not controlling. It does alternatively apply the correct standard, which is what the undisputed of facts allow the state to prove. And I mean, it was just a case with completely different facts. She said it's exactly the same thing. It's not. One of the facts disputed in that case, which was a vehicular case, a reckless driving case, was whether the defendant had accelerated at an unreasonable rate right before she hit the pedestrian. That was an actual factual dispute that goes to recklessness, and that could be dispositive. In this case, the state does not claim that he had a subjective awareness of a substantial risk that the firearm contained live ammunition. It's not disputed. For everything that Ms. Morrissey just said, they are not disputing that. She was candid. She did not sit here and say they can dispute that. There's a reason she didn't. They know they can't prove that. They know it would be inconsistent with what they told a jury to get a conviction of somebody else. They can't prove that. If they can't prove that, they can't establish the elements of the offense. And with that, I'll sit down, Your Honor.
Court makes the following ruling. The court denies the full and font motion of the defense. The court finds that, first of all, there does exist disputed facts before the court that are not capable of dismissal as a matter of law. The disputed facts are appropriately before the jury. The involuntary manslaughter talks about the defendant should have known of the danger, and I think that's really at the core of what is argued, that Mr. Bash is saying that there's no way he could have known, so there's no way he should have known. And Ms. Morrissey is saying here is some circumstantial evidence as to how or why Mr. Baldwin should have known. With respect to the inconsistent theories of prosecution, you didn't really bear that out. I don't think you've met your burden. I think that the 10th Circuit, U.S. versus Gandon Negro, is on point where it's got to go to the core, prevail on due process claim. It's got to go to the core, and that it's got to be, which is so inherently contradictory. And I think that I think part of what the state's relying on is what Ms. Gutierrez didn't do. Okay, and the court will prepare that order as well. I will see you back here at 1 o'clock. Does that work for everyone?
Your Honor, before we recess, I just have a question. The defense mentioned that I'm going to be arguing the Trombetta motion. We have 3 witnesses. The defense indicated they have witnesses. May we ask who they plan to call for that? I don't know if their witnesses are left.
Yes, Your Honor. As always, it somewhat depends in part on who the state calls. It may be that we don't have any witnesses if they're calling the same witnesses. So we notified Corporal Hancock, Mr. Ziegler, and Mr. Haig. But if that's the same set of witnesses, that the state, of course, will be efficient with the court's time and not recall people.
They are, Your Honor, same witnesses.
Okay, very good.
So then we will, yeah.
All right.
Thank you, Your Honor.
Thank you, Your Honor.
Real quick, Mr. Spiro, are you referring to Michael Haig or Luke Haig?
Luke Haig.
Okay. All right. Thank you.
All right. Thank you.
Thank you.
We're in recess.